Eric, I can't reclaim, and Gloria now can't reclaim. I don't know. Oh, my goodness, that is Joyce. Let me call her. Eric, somehow there's a second account. How do I remove them from the meeting and the other host?
Good afternoon, everyone. Welcome to this webinar that is being hosted by Greenfield Capital with CFA Society. Thank you for honoring our invitation. And since we are now quite a number, I think we should be able to start. Okay, so I'll just share my screen as we wait for other participants to join. All right, so we shall get started. The topic of the day is managing intergenerational wealth, the Ugandan contest, in collaboration with Greenfield Capital Limited and CFA Society. I'll start by introducing myself. I am Gloria Kambedha, the CFO/founder of Greenfield Capital, a company that provides estate planning services to individuals and families. Our mission is to help individuals and families to protect their legacies. I am a CFA charter holder, and my background is really in financial services. I have over 10 years of experience working in financial services. Greenfield Capital was born out of a gap that I realized in the estate planning industry when I was working in the financial services sector. And yeah, so we have been running with Greenfield Capital. It has been an exciting journey. I will invite my co-panelist, Alison, to also introduce herself before we get into the presentation. Alison.
Thank you, Gloria, and good afternoon to everyone on the call. Thank you for taking the time this afternoon to join us to discuss this timely yet underscored or underrated topic. My name is Alison Kwikiriza Serichasha. I am a lawyer by profession, advocate to be exact, with over 10 years post bar admission experience. I primarily focus on corporate commercial practice in-house and governance practice as well. Currently, I am practicing in the capital markets industry, specifically the Uganda Stock Exchange, where I head the legal department. But in addition to that, I do independent consultancy, hence the collaboration with Greenfield Capital on the regulatory aspects of estate management and estate planning. I'm a member of the Uganda Law Society, the East African Law Society, as well as the Governance Institute, formerly ICSA UK, and the Chartered Institute for Securities and Investment I am delighted to be sharing this conversation with members from the CFA Society, and I hope we can have an insightful discussion on these issues that are being discussed today. Thank you. Back to you, Gloria.
Thanks, Alison. So our agenda for today, we shall first of all give an overview of what Greenfield Capital is all about. Then we shall look at estate planning in the Ugandan context, the Ugandan market. Then we shall look at the legal landscape, what are the regulations. And then finally, we shall look at the trusts and trustees, which is a topic that has really been of interest to so many clients that we have had. So I'll jump straight in. Greenfield Capital, we specialize in working with individuals and families to preserve their legacies through our various service offering. So on an everyday basis, we all participate in estate planning, whether that is choosing the investments that you want for to grow your money, whether it means taking up a certain kind of job, whether you should start that business, it's all estate planning. So what we are doing is ensuring that our customers have formal estate plans to protect the legacies that they have built or they are building. And we do this through our various service offerings. So our services include wills. So we help our customers draft wills. If they already have existing wills, we help to review the wills. And we also help with updating wills and their custody. So our goal is to ensure that our customers have valid wills in place, and also whether a will is actually the proper estate planning vehicle. We also help with trusts, trust creation, a review of trust deeds and all that as an estate planning vehicle. We also support with powers of attorney. A power of attorney is really who is going to make for you a decision in case of incapacitation. So we also support our clients on that. We provide trustee services, which we shall be discussing later on in this presentation. We also provide independent corporate executor services to ensure that the wishes of our clients are executed, are brought to life. And we also provide legacy valuation and advisory services, which include business succession plans. So our value proposition as Greenfield Capital, one, we have a diverse skill set. We have professionals who are qualified in tax, law, finance expertise. Estate planning is a multifaceted discipline, and it needs quite a diverse skill set. So we are able to give our clients that diverse skill set. We also have perpetual succession as it's a client, as it's a corporate. So our clients can be assured of service for time to come. And you see, given the nature of estate planning, you're serving intergenerational, clients. So it's very important for whoever you choose to do your estate planning to be assured of their existence for time to come. And since we are a corporate, we offer this to our customers. Then we also we make savings for our customers in terms of money and time. When a customer dies intestate, there's a lot that goes in terms of time, money, legal costs that go into settling that kind of estate. So we save our clients money. And then finally, neutrality, confidentiality, and professionalism. Because of our corporate nature, our governance structures, we are able to offer a service that is confidential, neutral, and professional, which are all very important aspects of estate planning. So I'll go into the estate planning in the Ugandan context. I'll start a few statistics. Uganda is a very entrepreneurial country. 94% of businesses are sole proprietorship. But what does that mean? That means that they do not have the structures to ensure continuity. So that continuity is not there. We find that business owners spend all their lives building a certain business, and then all that value evaporates when they die. So that just goes to show you that estate planning is a very important aspect. 17% of local businesses have been operating for at least 2 decades or more. So that also speaks into, 2 decades is just 20 years, and you only have just 17% surviving. And that speaks into the succession planning models that are existent. So we work with business owners to ensure that, they have succession plans in place. And then also the other statistic, 26% of Ugandan business owners said they have a succession plan, and less than 20% have a testament or will. This is according to a survey by PricewaterhouseCoopers. So you can see that the statistics really point to Ugandans really neglecting matters to do with estate planning, which is something that we are working on at Greenfield. So one can ask how much wealth has been lost over the generations. We've had land that has passed from generation to generation, or it has been lost in between generations. So one wonders, due to the nature of our, how we run our affairs, one wonders how much wealth has been lost in between generations. I'll also speak into our social and cultural norms which affect estate planning. Owning land and property is perceived as part of the Ugandan dream. Keeping it across generations can be a nightmare. So as Ugandans, we really love property. We consider it as a store of wealth, and it's really a dream, but keeping it across generations can be a nightmare. Then there's the issue of ownership versus possession, challenges of people occupying property but not having rights to bequeath it. So for example, some of the things that really stand out. So for example, you have a family, the head of the family, that is the father passed on, and the property was not transferred into the names of maybe the other spouse. So what happens when the other spouse passes on? So that it would be that the relatives of the spouse who passed on first will have rights to that. So we are seeing that people, yes, occupy property, but they have no rights to bequeath it. They don't own it. And it also speaks into our social culture norms. Polygamy, 25% women reported that their husbands or partners have other wives. And this is really not a problem. Polygamy is accepted, but as a polygamous society, there is need really to just document where do you want your assets to go, how, so that you stop all those the wrangles that have to do with that the confusion that comes up without a formal estate plan. Then also documentation, family history documentation is non-existent, and yet this can be very helpful in helping families appreciate and want to build, to conserve their legacies. So based on all those social and cultural norms, you will agree with me that estate planning is much needed in a society like ours. So people are getting more knowledgeable on how to manage their affairs. with the different vehicles that we have in place. The most common is administration, and since over 95% of Ugandans die interstate, this is really the most common route. So most estates go through administration, through the Administrator General, but we all know that the challenges that can arise with such an estate planning, vehicle. There's a backlog. There's a backlog. There's some money you need to pay, so it can be quite a long process. By the time the beneficiaries get the property, it can be prone to mismanagement and all that. So yes, administration is the most common route. And then wills are getting more prominence, wills basically just help you with the distribution of your estate upon your demise. A will has to be valid in order for it to avoid being contested in the courts of law. So wills really just help you with how to distribute your property, appoint guardianship, make beneficiary designations, and also appoint executors. The biggest consideration for wills is that it should be a valid will in order for it not to be contested in the courts of law. Now, because of the challenges of wills, the trusts are becoming more reliable and common, and they help one to avoid the probate process. We shall be speaking more into trusts later on in this presentation. But really, trusts help you have that privacy, and a will becomes public as soon as you pass on, but a trust is more private. However, we are going to speak more into trusts later in this discussion. So, estate planning that is targeted towards multiple generations of ownership is not simply doing a will. It is not a one-size-fits-all. It requires careful introspection and advice from professionals. So depending on your circumstances, a will might not be the right tool. It depends on quite a number of unique circumstances. So just because you have done a will does not mean that your legacy will be protected throughout the generations. And in the next slide, I just want to speak into the different circumstances and what estate planning vehicles that can be considered. So for example, if you have a simple estate where your goal is just distribution of property, here you can opt to use a will. This is basically for people really who you just want to distribute the property and you do not care what happens to that property afterwards. You should note that once you've transferred property in a will, it transfers to the beneficiary, so they can choose what they want to do with that property. And then if you have minors, children, bequeathing property to minors can be a bit complex because they cannot manage that property on their own. So in that case, you might need testamentary trusts or living trusts, which we are also going to speak into later. So because children cannot be able to manage the property in the unfortunate event of your death, it's advised that you use trusts for that. Then if you have family property, for example, you want to maintain, you have ancestral homes and other property that you want to preserve in the family for generations, again, trusts would be more suitable for that, because they kind of conserve that the property in the family for for generations. And then if you want greater control over the management of your assets. So with a will, as I mentioned, you'll not be able to have control over the management of the assets. But with a trust, in a trust deed, you can be able to provide for all those items. And then if you want to ring-fence property, for example, if you're entering into a second marriage and you sort of just want to isolate your assets from the first marriage, or you want to ring-fence your property from debts, a trust would be more reliable for that. Finally, flexibility. So if you prefer to have flexibility in terms of how you want to manage your assets, trusts are more suitable for that. And then there are cases where clients have needs to do with special circumstances, like you have special needs children, dependents with special needs, mental health challenges. For that case, estate planning using trusts would be more appropriate. So I will invite Alison to take us through the legal landscape.
Okay, thank you, Gloria, for that, for those insights. Mine is really simple. It's to take participants through the regulatory considerations and the key aspects of the law when it comes to inheritance and succession, as well as the different options that Gloria was talking about. But later on in the presentation, I'll primarily focus on how you can utilize the trusts and the key considerations as you consider this as an option in your estate planning journey. So in terms of the regulatory environment, we do have a couple of regulatory frameworks that guide when it comes to succession or inheritance law, as it is called. We start with the Constitution, which is at the top of the hierarchy. Why is the Constitution relevant? Because it is looking at, it is the principal document that provides for the right to property. It also provides for the obligation to protect widows and children when their benefactor has passed on. So any other provision of the law, any other legal provision that is contrary to the Constitution to that extent would be considered null and void. The second regulatory consideration when it comes to the inheritance regulatory framework are the statutes or the written laws. And in the Ugandan context, we primarily look at the Succession Act. And the Succession Act really lays down the detail of who is a beneficiary, what happens when you when someone passes on without a will, what happens when someone passes on with a will, what are the key considerations to designate it as a valid will, what is the role of court in validating a will or appointing an administrator in instances where someone has passed on without a will. What are the key definitions of beneficiaries in terms of children, in terms of a spouse, in terms of dependent relatives, It also brings out the issue of, or the relevance of domicile, or where a person is domiciled, and the relevance that has in terms of the inheritance of their property in the unfortunate event that they pass on. The other relevant written law would be the Trustees Act. Now, the Trustees Act is more relevant where someone has opted apologies for that, where someone has opted to pursue the vehicle of a trust as a legacy protection model. And we'll see later on in the presentation what protections and what critical provisions come through from that act. And then the Limitation Act, Cap 80, which is relevant in terms of laying down the maximum time frame within which someone can claim their benefits from a deceased estate. Other than written law, the hierarchy continues. We have case law. A lot of matters have been decided through court, and they have since then been recognized as applicable law in far as inheritance matters are concerned. Then common law and doctrines of equity. In the Ugandan context, we do follow the common law regulatory regime. So a lot of our principles do draw from the common law principles. But as you can see in that descending hierarchy, the constitution, the written law, and the case law that is decided from courts within the Ugandan jurisdiction would take precedence. Then we also have customary law, which is recognized as an applicable law when it comes to inheritance. And perhaps one of the examples that I could give is the Bruno Chihuahua case, just to show that we have all these laws and they coexist in terms of application. And in most instances, courts and whoever is applying the law will be required to look at the different provisions in the different sets of laws, so that a prudent decision can be made taking into consideration all the existing circumstances. So for instance, this particular case, the Bruno Chihuahua case, I don't know how many of you remember it, but Bruno Chihuahua sued his daughter and her fiance because they wanted to get married, but they were both from the Ndiga clan. And he brought the matter to court, and his argument was, I appreciate that the Marriage Act does not prohibit people within the same clan getting married, but you must take into consideration the unwritten customary law in the Buganda culture that people in the same clan cannot marry. And courts actually agreed with him and indicated that it could not, despite the fact that customary law appears to fall in below the written law in the hierarchy of application of laws, they deemed it prudent at that point to take it into consideration. And this is just to highlight that there will be instances where different customary practices will be adopted when determining certain legal matters. And even as we are talking about estate planning, it is important that you take into consideration your own circumstances and the extent to which they facilitate or enhance the estate protection model you have chosen, or the risks that come with that particular model, taking into consideration your own customary circumstances. So that is an overview of the regulatory environment that we have when we're dealing with inheritance or succession law. Gloria, if we can move to the next slide. But in terms of the key features, what all these laws are generally talking about is what constitutes an estate in terms of the property. And here we're really looking at ownership. So when someone is talking about succession law, it should be able to point you to the issue of ownership. What does it say about owning of property? In most instances, the clear-cut disputes on ownership will be around who owns the title, the registration, but there are other areas that are relevant when it comes to especially succession law, issues of co-ownership versus joint ownership. If Gloria and I decide to own a piece of land together, have we clearly indicated under what ownership model we are proceeding? Is it co-ownership in that we can ascertain my portion 50%, in which case if I did pass on that 50% then devolves to my estate? Or is it joint ownership, in which case you're not able to ascertain or allocate specific percentages of ownership, in which case the last to survive will take the entire property and their estate would be entitled to that particular property? Who is entitled to benefit? Who are the eligible beneficiaries? In the Ugandan context, we do have those definitions of who is a beneficiary, who is a dependent relative. Is it merely someone that you send support to every month, every now and then? Or you need to look at the context within which the law defines a dependent relative in terms of someone who derives their major sustenance through your support, shelter, food, education, definition of a spouse, definition of children. For those of us that are from other jurisdictions, perhaps it would be good as you are doing your own estate planning to counter-check the regulatory provisions around these definitions, because sometimes they do vary from jurisdiction to jurisdiction. Then how do you make sure that people benefit from your estate? And that is where the discussion of a will, a valid will comes in, and trust, and how you set up that particular trust so that it is aligned with the expectations of the law and it cannot be contested. And then finally, what are the acceptable proportions when it comes to allocation of property? And can you keep this in mind even as you are coming up with your will, so that you're cognizant of those outliers that bring risk to your will in terms of contestation of its validity? So these are some of the issues that are key from a legal perspective when we talk about succession law, and which are very relevant as someone is coming up with either their will, or if they decide to go the trust model route, setting up the trust. So speaking to trust, which I think is the key area of discussion in terms of the estate planning model that is selected for this discussion. A trust is simply the creation of a fiduciary relationship. Me, for instance, if I'm the trustor or the grantor of a trust, I look for a party that I feel has the sufficient knowledge and I believe is capable of executing my wishes, and give that person the right to hold title to my property or my assets for the benefit of a third party who at the time is not able to manage that particular property or asset. on their own. There are different types of trusts, but in the context of succession law or in the context of inheritance, we look at two types of trust. The testamentary trust, which is a trust that is created by will, by a will, and then the living trust, which is a trust that can be created even while you're alive, managed in part by you, and at the point of your demise can have an inbuilt transition mechanism that allows for a continuity in terms of administration and management. So when we talk about trusts in the context of inheritance and succession and estate planning, those are the two we are looking at. Specifically for the testamentary trust, its key characteristics are that it must be created and funded at the time. So when you create that particular trust, which is really that you will indicate in your will that you have created a trust for the benefit of so and so, and you will also indicate the property that is designated to that particular trust. And these trusts are irrevocable in nature for the testamentary trust, meaning that, of course, they usually take effect, not usually, but they do take effect once the person has passed on. And of course, at that point, it is impossible to revoke since the creator will no longer be with us. But for living trusts, it is a bit slightly more flexible. You're able to create it within your lifetime. As a truster, you can work or appoint yourself a co-trustee with other trusted people that you appoint as trustees. There is no requirement for you to have property funded or designated to that particular trust as at the time of its creation. However, of course, the expectation is that as you move along, you will be able to designate particular property to it so that it is relevant for the beneficiaries whom it is intended to go to. And it can be revocable or irrevocable, but those actions need to be taken during your lifetime or the lifetime of the person that has created the living trust. So just in terms of the ingredients for creation of a trust, really we're looking at you or the truster, the person who is creating the trust, trust property, for testamentary wills needs to be in place and designated at the time that you're creating that trust in the will. For living trusts, probably not, but you should have in mind or along the way, there has to be that intention to allocate property to that particular trust. Otherwise, it would defeat the purpose of creating the trust. Then trustees, you need to find responsible, knowledgeable people that can be trusted insofar as managing the trust property is concerned. And this is particularly because different from a will where you have an executor whose primary role is to distribute the property according to your wishes, a trustee's role is broader than that. A trustee's role involves a lot of discretion. It involves a lot of knowledge in terms of investment management and making sure that the trust in itself or the property that is allocated to the trust is able to generate income that is able to benefit the beneficiaries in the manner which you intended them to benefit. So who you choose to act as a trustee is a very delicate and important matter. And I think a lot of recommendations around this area are pointing towards looking at corporate entities that have that, first of all, knowledge and experience, but also which are much easier held accountable when it comes to failing on their fiduciary responsibility. to the beneficiaries. In terms of the mode of setting this up, it depends on what trust you're looking at. If it's a testamentary trust, like I mentioned earlier, you're going to designate this or create this in a will by writing down the specific beneficiaries for that trust, the trustee, and allocating that property to the trust, to that particular trust. But if it's a living trust and you're creating it in your lifetime, then the appropriate document would be a trust deed. And later on, shortly after this, we shall look at the key components of a trust deed and what you should look out for as either you're preparing it or you're reviewing something that has been prepared for your benefit. Just going back to the issue of duties of a trustee, like I'd mentioned, it is important that you carefully select who you're appointing as a trustee. The duties of a trustee are regulated under the Trustees Act, but we also have common law principles that put in place basic expectations of how a trustee is expected to operate, especially because whereas the property vests in them, it is not their property and they're holding it on behalf of the actual beneficiary. And the expectation is that they will ensure that the beneficiary gets the full benefit of the trust property that the trustor intended them to have. So one of the duties or the principles that are laid down both in the Trustees Act and common law principles is the fiduciary responsibility of the trustee, which means that the trustee is bound to act in the best interest of that beneficiary. Their primary jobs include investment, and that is why it is important as you're selecting someone, to make sure that you get someone that is quite knowledgeable in contemporary investment matters, and they're able to make sound investment decisions, not only based on their own, not based on a hunch or a gut feeling, but on based on from an informed point of view, if I may say. Of course, they have administration, and at some point, depending on what the provisions of the trust did entail, distribution to the beneficiaries. It is a duty that one takes up knowing that they are personally liable for anything that could go wrong. So as a trustee, if there is any misgiving around to the management or mismanagement of the trust property, and a beneficiary or anyone else that has the mandate to bring your liability into question, petitions court, then you will need to demonstrate that, one, you've acted in the best interests of the trust, that you have made sound investment decisions, whether it means investing somewhere or whether it means divesting particular property, because as we know, there's property that it may not make sense to maintain particular property for matters of depreciation or loss of value, and it may actually make sense at that point in time to divest it and probably get the value for money at that point. But if there is a question regarding whether or not that was a sound decision, then you are personally liable, and you'll have to demonstrate the extent to which that decision was made from an informed point of view, and if it was actually in the best interests of the beneficiary. And just point number 4, as indicated there on the screen, that's just to say, given all that information, we should not confuse a trust relationship and a relationship of agency or a relationship of an executor or administrator, because like I mentioned, an executor or administrator, all they're expected to do, even from a legal perspective, is to collect the estate of the deceased in terms of making the inventory, what falls within the deceased estate, and then distribute the property according to the wishes of the estate. The trustee's role is broader and can exist for a longer period, especially when you're dealing with instances of minors, or even when you're dealing with instances where you have beneficiaries that are incapacitated for life. We have children with special needs, or people that may not be as able, and recently we've also had a bit of a discussion going on mental health. So if you do decide to create a trust so that you can take care of those specific categories of dependents way after you or someone has passed on, then those are some of the key considerations to look at when you are looking for a suitable trustee. If we can go to the next slide. Yes, and maybe just to wrap up on the issue of trust creation. So what are we looking for? Or what would you be looking at if you're thinking about creating a trust? Identify the trust property or the property that would be designated to that trust. And another thing I need to mention is a trust and a will do not have to be applied separately. They're actually documents that can coexist. So you can identify trust property that is specifically designated under that trust, looking at the special categories of beneficiaries that you intend to target. So you're looking at the trust property, the beneficiaries, and then the terms of access. Are you putting conditions that the trustee needs to take into consideration when it comes to access by beneficiaries? Say, for instance, are you creating a minors trust and saying that when they turn 18 or when they turn 21, then they can have access, or are there additional considerations that you may need to include in the terms of access? Registration of a trust, whereas this is not mandatory. Registration of a trust deed, whereas this is not mandatory. It is something that can actually, that would be important, because from a legal perspective, when you register a document, on the face of it, it is evidence that is admissible in court, and it will be easier for you to adduce it as proof of an existing trust relationship created. So that is highly recommended. I already spoke to the issue of trustees' competence. Not only do you need to select someone that is competent, but these people need to be in the know, and they need to consent and append their signatures to the trust deed. It's not enough for you to assume that someone is a good option. You need to go a step ahead and get their consent and have them append their signature to the trust deed. And then provisions on trust property management and investment. I see a lot of you are from the society, so it's sort of a personal investment policy statement that is embedded in there. What are your preferences when it comes to investment? What in terms of the asset classes? What are your preferences when it comes to the point at which it is acceptable for property that is within the trust to be divested? so that value for money is gotten out. What are your thoughts on using property within the trust to acquire loans, especially if it is for the benefit of the beneficiaries? We all know that we do have a rather expensive education system. What if it gets to a point where your beneficiary, there's trust property, but it is not in liquid form? Do you have something to say about borrowing and liening the trust property? So all those details would be important, and it is important that as you are communicating to the person that is supporting you draft this trust deed, that discussion is held, and your preferences are documented in detail, and even issues of transition from one trustee to another, especially if you're creating a living trust, are also documented. It is a living document, so you have the leeway to make adjustments, provided you're still alive. Similarly, even the testamentary trust that is created in the will is also something that can be amended by amending the will, which is what is called the codicil, and any additional considerations taken into any additional provisions taken into consideration at that point in time. I think I'll stop there for now and hand back to you, Gloria.
Thank you, Alison, for that detailed presentation. I think we shall go straight into the questions and answers, since we've already overshot that time. I think this one will go to you, Alison. Wouldn't the provisions of the marriage bill conflict with some of the operations of the trust, e.g., like when one is entering into a second marriage?
Well, I would say, Oscar, it depends on what type of marriage we're talking about. Obviously, in terms of a church marriage, you would have a challenge getting a second marriage recognized, but that is not to say that, and also the second spouse in the context of a church marriage and looking at the definition of a spouse would not be recognized. However, their children would be recognized as eligible beneficiaries. However, when it comes to customary law, where it is permissible to have more than one wife, and if that is the context of the marriage, then it is very possible to designate particular property in a particular trust that is related to that marriage, and other property in another trust that is related to that other marriage. So it really depends on the kind of the category of marriage that we are talking about here.
Okay, thanks. I hope that has been answered, Oscar. The other question, I think there's a question on taxation of the trusts, which I think, Alison, you can speak into, because it depends on the type of the trust. So I'll also leave that to you, Alison.
Okay, tax implication for trust. So for starters, there are two options. You may create a legal vehicle through which the trust is implemented. And by legal vehicle, I mean you can register a company limited by guarantee and have that as a trust, which is usually what, for instance, the route that charitable organizations and like trusts do. In terms of the tax implications, we are really looking at income tax, and the tax is applied on the income that is going to the beneficiary of the trust. So whatever income, if you've created a trust as an individual, if you've used a trust deed and you've appointed the trustees, the property is vested in them, then the tax implication there is that when the beneficiary receives the income from the trust, then there is that income tax that is applicable. I think it is you use the same brackets as payee. In terms of the trust that is now a legal entity, again, what is being taxed is the income that is coming from the trust in any given year. Unfortunately, I would not commit on the percentage for that, but I do know that for a non-resident trust, the chargeable income would be 30%. But for a resident tax, for a resident trust, I think I would need to confirm the percentage that is chargeable there.
Okay, thank you, Alison. I think I'll move on to the next question. Is it possible to leave your estate to your kids, but leave a condition that doesn't allow them to ever sell it? If so, under what conditions can it be sold? I'll take this. So here you want control over your estate for generations, and the best way to do that is through a trust, because a trust enables you to set up all those conditions. So once you bequeath property through a will, you might not be able to leave those conditions of never selling. So it would be more advisable to set up a trust, appoint trustees who can ensure that it is never sold. And as Alison already spoke into that, a corporate trustee would be the best person to appoint because of their perpetual succession. And then the next question is, since this takes effect after one has passed on, who will make the distribution of returns and other management decisions, let's say after like 100 years, if the original beneficiaries have passed on and we are on the third generation? Alison, would you please take that?
Sorry, can you just repeat the question? I'm trying to
I think the question is mainly about who is going to take the management decisions after, say, 100 years, if the original beneficiaries have passed on, and for example, we're on the third generation.
Okay, so if we're talking about a trust specifically, the trust deed needs to have transition mechanisms for the trust property. And again, it is also recommended that you have at least 2 or 3 trustees so that there is that check and balance and that historical, there's that seamless succession process if one or more of the trustees is no longer there. But what would need to happen is to provide for the transition, a clear transition process from one trustee to another under the trust deed. Of course, again, depending on the kind of property that you are talking about, you may have a trust that looks at beneficiaries coming of age, and at that point, the property then can be distributed, the property or whatever income has been amassed in that trust can be distributed to the beneficiaries. But in the context, say, of probably family land or the burial grounds that Gloria had hinted on earlier, there has to be that mechanism through the trust deed that allows for that transition trustee to trustee and takes into consideration the need to have it running through the different generations.
Okay. Thanks, Alison. There's another question here. Good evening. In regards to investments, Does Greenfield Capital invest in well-established capital markets such as New York Stock Exchange, LSE, or are you limited to capital markets in East Africa? Thank you. To answer that, Greenfield is a trustee, so we really invest according to the mandate in the trust deed. So if that, and it's a private arrangement, so because of that, we are able to follow whatever mandate is in the trust deed. Yeah, so I hope that answers your question, Josephat. There doesn't seem to be any more questions. Anyone, if you have a question, please put up your hand, sorry, so that we can answer before we go offline. And yeah, there doesn't seem to be any more questions. So thank you all for making the time.
From Oscar.
Oh, there's a question?
Yes.
For an irrevocable trust, would this condition apply for generations to follow on, or it applies only to the settler? I think this is a follow-up question. Alison, can you take up this? I think
okay, so yes, it would apply for the generations to follow, because really, like the term suggests, it is irrevocable. And depending on the transition provisions that carry it forward to the next generations, that would then determine how it applies to the next generation of beneficiaries. But like the name suggests, it is intended to be a rolling trust, and it cannot be especially once the truster has passed on, then it cannot be revoked.
Okay, I think that answers it. Thank you, Alison. Thank you all for making the time to attend this webinar. We shall make the recordings and the PowerPoint presentation available via email. In case you need any further assistance on your estate planning needs, please feel free to contact us. Greenfield Capital, info@greenfield.com. Our website is www.greenfield.com. And we are also available on the social media handles on the handle at Greenfield across all the social media channels. So I'll consider the webinar over. Have a good evening. Bye.